The legal system, in its purest form, aims to provide a fair and just resolution for disputes. While the common law, with its rigid rules and precedents, often struggles to achieve this ideal, equity and trusts emerge as crucial tools for ensuring fairness. Equity, rooted in principles of fairness and conscience, tempers the harshness of strict legal rules. Trusts, on the other hand, provide a versatile mechanism for managing and safeguarding assets. Trusts and equity are not merely abstract legal concepts confined to dusty law books. They play a pivotal role in our daily lives, often without us even realizing it. From managing inheritances and securing financial futures to charitable giving and protecting vulnerable beneficiaries, trusts are pervasive. Understanding these concepts is essential for anyone seeking to navigate the complexities of asset management, property ownership, and inheritance planning. This essay aims to demystify the key principles of equity and trusts, making them accessible to those without a legal background. By exploring their historical development, examining the requirements for creating a trust, and delving into different types of trusts, this essay will equip readers with the knowledge to understand the significance of these legal instruments in contemporary society. To truly grasp the essence of equity, one must journey back in time to its very roots. In medieval England, the common law, with its rigid adherence to precedent and technicalities, often resulted in unjust outcomes. Petitions for more equitable resolutions, initially directed to the king, eventually found a more permanent home in the Court of Chancery. The Court of Chancery, presided over by the Lord Chancellor, became synonymous with equity. Guided by principles of fairness, conscience, and good faith, the Chancellor addressed situations where the common law fell short. This parallel system of justice introduced remedies unavailable in the common law courts, such as injunctions and specific performance, providing more nuanced solutions to legal disputes. This historical context underscores a fundamental difference between equity and the common law. While the common law focuses on strict adherence to established rules, equity emphasizes fairness and flexibility. This distinction remains relevant even today, as equity continues to supplement and refine the common law, ensuring that justice prevails even when legal technicalities threaten to obstruct it. A trust, in its simplest form, is a legal arrangement where one party, the settlor, entrusts assets to another party, the trustee, to hold and manage those assets for the benefit of a third party, the beneficiary. However, creating a valid trust requires more than just a desire to benefit another. It demands adherence to three fundamental principles, often referred to as the three certainties. The first certainty, certainty of intention, requires that the settlor expresses a clear and unequivocal intention to create a trust. Mere wishful thinking or vague expressions of hope are insufficient. The settlor must demonstrate a definite intention to create a legally binding obligation on the trustee. Secondly, certainty of subject matter mandates that the assets being placed in trust must be clearly identified. Whether it be real estate, money, or intellectual property, the specific property subject to the trust must be easily ascertainable. Vague descriptions or attempts to create a trust over unidentified future assets will fail. Finally, certainty of objects dictates that the beneficiaries of the trust must be clearly identifiable. The trustee must know with certainty who is entitled to benefit from the trust. Without this certainty, the trust cannot be enforced. Section 4. Navigating the labyrinth, different types of trusts. The world of trusts is not monolithic. It encompasses a diverse array of trust structures, each tailored to specific purposes. Understanding these different types of trusts is crucial for individuals and families seeking to protect assets, manage inheritances, or plan for the future. One common type is the express trust, explicitly created by the settlor, usually in writing outlining the terms and conditions governing the trust. In contrast, a constructive trust arises by operation of law, often in situations involving unjust enrichment or breach of fiduciary duty. Resulting trusts, another category, arise when a trust fails to dispose of all the trust property, resulting in a portion of the assets being held on trust for the settler. Furthermore, trusts can be categorized based on their purpose. Charitable trusts, for instance, are established for charitable purposes, benefiting a particular cause or the public good. Discretionary trusts grant the trustee discretion in distributing trust assets among beneficiaries, while fixed trusts provide each beneficiary with a predetermined share. Understanding these different types of trusts empowers individuals to select the most appropriate structure for their specific needs and objectives. Section 5. Landmark cases illuminating equity and trusts in action. Legal principles often come to life most vividly through the lens of real-world cases. Landmark cases, with their intricate fact patterns and nuanced legal reasoning, provide invaluable insights into the practical application of equity and trust law. One such case is Saunders v. Vautier, 1841, which established the rule that beneficiaries who are of full age and capacity can collectively terminate a trust and claim the trust property, even if the trust instrument stipulates otherwise. Another significant case, Knight v. Knight, 1840, solidified the requirement of the three certainties for the valid creation of a trust. This case emphasized that a trust cannot be enforced unless the settler's intention to create a trust, the subject matter of the trust, and the beneficiaries of the trust are all clearly defined. These cases, among many others, highlight the dynamism of equity and trust law. They demonstrate how courts, guided by principles of fairness and justice, interpret and apply legal rules to resolve real-world disputes. By studying these landmark cases, we gain a deeper understanding of the principles at play and their impact on the lives of individuals and families. Section 6. Conclusion. The enduring significance of equity and trusts. In an increasingly complex legal landscape, understanding the principles of equity and trust is more crucial than ever. These concepts, far from being relics of the past, continue to shape our legal system and influence our daily lives in profound ways. From protecting vulnerable beneficiaries to ensuring fairness in business dealings, equity and trusts remain indispensable tools for achieving justice. As we navigate the intricacies of property ownership, inheritance planning, and asset management, a firm grasp of these principles is essential. Whether we are establishing a trust to secure our children's financial future, making a charitable donation, or simply seeking to understand the legal framework governing our assets, knowledge of equity and trusts empowers us to make informed decisions. By embracing the principles of fairness, flexibility, and conscientiousness that underpin equity and trusts, we contribute to a more just and equitable society for all. As we move forward, these principles will continue to guide courts, legal practitioners, and individuals alike, ensuring that justice prevails even in the face of evolving legal challenges.